The ones ensuring the job always gets done, and the ones wearing many hats. Granger offers professional grade industrial supplies and real time product availability.
I'm so
Call
sorry. I do
clickgranger.com
not.
or just stop by.
So sorry. That was the whole YouTube problem. Jesus.
The internet is being wacky today. I think so.
Yeah,
Mhm.
Mercury is in retrograde. So going to try the screen sharing again. Okay. And then recording. Um, oh, pause and stop recording. Oh, wait. So actually, it looks like the recording is going. That's great. Okay. I'm so sorry. So Sam, I don't know if you wanted to introduce yourself real briefly, and then
Sure.
we can
Yeah.
kind of get into
Hi.
it.
Yeah. Hi, everybody. As I said, it's so encouraging to see so many people from all over the city, who are dedicated to advocating for tenants. My name is Sam Kiera. I'm the director of litigation for Communities Resist. We're a legal services nonprofit. What we do is primarily help groups of tenants, tenant associations, bring lawsuits against their landlords for repairs and against harassment and discrimination in Brooklyn and Queens. And we do that with community-based organizations, tenant organizers, and we also have our own small team of tenant organizers who work with us here. I'm here to talk to you guys today about how to counsel people who are about to navigate the world of non-payment eviction in housing court. There are a lot of resources and a lot of tools available. As I think everybody here is aware, the world of housing law is very complicated. And there are many potential defenses available to any litigant. Um, but I'm going to go through some of the basics. And really what I would like to do is what I would feel best about is if at the end of this presentation, you guys feel that you are able to counsel tenants so that they are not as afraid going into non-payment proceedings. Because for a lot of tenants, there is a resolution that doesn't require that they be evicted in the end. And we'll talk about that. There are also lots of points along the way where tenants have an opportunity to speak with attorneys like myself, um, and ask for help in navigating this world. Again, the nice thing about non-payment is that the landlord is ultimately asking for payment of rent, um, or if the tenant doesn't pay rent, then to take possession of the apartment back, right? But if at any point along the way the tenant is able to come up with the rent, it's just story over, right? The tenant may have the extra issues, and we can talk about that later. But as far as the danger of eviction, if the tenant can pay in a non-pay, that's that's the end of the story. Okay. So yeah, so what to expect from the court process? Oftentimes I staff a clinic twice a month at Assemblymember Davila's office. And oftentimes we'll have tenants who come in facing non-payment evictions, and the housing insecurity is very serious. It's a very real thing. And so they're terrified. And what one of the services that you can provide for them is to tell them what to expect, right? What's the timeline look like, right? Often tenants don't know that they're not going to be evicted within a week, or because they're supposed to answer within 10 days. They don't understand that that they're not going to be evicted just for answering, right? Just at that time or at their first appearance, right? And you can see why there are a lot of states where that kind of thing happens, right? But New York has a lot of protections for tenants, whether they're regulated or not, right? The nice thing about the way that New York housing law works, and a lot of people get this kind of confused because they think of this as like a squatters' rights thing. It has nothing to do with squatters' rights. If someone has been in an apartment lawfully for 30 days or more, then they're just entitled to eviction by court process, right? And so a lot of people mistake that for like, oh, they have a vested right all of a sudden in the apartment. That's not true. What they have a vested right in is due process in their eviction, right? And so I'm going to try and walk you through some of the process, right? It's a long, long road, even if the tenant gets evicted, right? But as I said, there are lots of off-ramps on the way. And please let me know at any point if you guys have questions. Next slide, please. Okay, so predicate notices. So, as I said before, a non-payment case, you get certain notices that allow you or the tenant to avoid the case altogether, right? A lot of times this is not possible. If a tenant has really fallen behind on rent, right? And isn't able to pay, they're probably going to have to go through some part of the eviction process. It doesn't mean they're going to get evicted, but it may mean that they're going to have to go to court, right? But what the predicate notice does, this 14-day notice, is it says, tenant, you owe me this many months of rent. And it should say when the rent came due, right? And how much rent was owed for each month, right? So like you didn't pay for December, January, and February, right? And this is how much was due in each of those months, right? And so now if you don't pay me within 14 days, I have the right to begin a non-payment proceeding against you, file that in housing court, right? But what it starts off with is this 14-day notice. A lot of the time, or sometimes I'll hear from tenants, well, this doesn't look like court papers, right? And that's because it's not court, but they're not court papers, right? 14-day notices are notices that are sent out by the landlord or the managing company or the landlord's attorneys sometimes, right? And what they say, really, as I said, is if you can pay this rent, you can avoid the court process, right? And we won't file a case, and you won't be in any danger, right?
Second, it's brought by the process server, or you could give it to the tenant directly.
Okay, this is a really, thank you. That goes right into my next point on the slide. Yeah. So yes, 14-day notices to pay have got to be served in the same manner that the notice of petition and petition is served, and that is usually served by a process server, right? And we'll talk a little bit more about service, but it's good to pay attention to when the process server says they attempted to serve you and how for reasons that we'll get into. Again, yeah, only after the 14-day notice has expired does the landlord have the right to proceed in court against the tenant. Next slide, please. Okay, so here's what a 14-day notice looks like. Again, yeah, so this is a kind of older notice. But it says what the tenant owed and what months they came due, right? You can see that at the top it says you owe the landlord a total sum of this amount of money, right? That's not sufficient on its own, which is why this landlord has said, you owe me this total because this became due this month, this became due the next month, this became due the next month, right? Again, this is not paper that these aren't court papers. These are sent out by the landlord or the landlord's attorney directly to the tenant. And that's because this may never turn out to be a court issue, right? I actually recall what happened here because this was a case of mine. And in this case, the landlord had changed offices. And as a result, the money orders that the tenant had been mailing to the landlord were not being sent to their new office, right? And so this was an easy problem to solve. But if the tenant had been sitting on the rent or hadn't known where to pay the rent and then had found out after getting this notice, then the tenant could go and pay and avoid the eviction. Proceed. Okay, so service of papers, right? So court papers, including the 14-day notice, the notice of petition, and petition are served pursuant to RPAPL, that's Real Property and Proceedings Law, Section 735. And that's technical, and the only reason why I'm adding it here is because if you ever want to see what the requirements are for service, that law is super readily available by just Googling RPAPL 735, and you can just read through it, right? It's legalese, it's a little complicated, but it'll tell you exactly what the landlord has to do in order to serve a tenant correctly. For eviction papers, for eviction cases, service is really pretty relaxed. It's not the way that you would imagine like a Supreme Court case, like a case in state court to be served, right? They don't actually have to find the tenant. They just have to attempt to find the tenant twice at home. They have to try and find them once during business hours, once outside of business hours. And if they haven't found them on the second attempt, they can leave the papers, right? They're supposed to post the papers. It doesn't matter if they leave them on the floor. You're not really, that's not, it doesn't matter, right? They could put them under the door. They can leave them on the floor in front of the apartment. How they leave the papers is not very important, right? And then they have to follow up with mailing within 24 hours, right? Oftentimes a tenant will only get the mailing, right? If that happens, then you want to find you want to help the tenant find, or at least make a note of it so the tenant can later find the affidavit of service to see when the process server says they attempted to knock on the door and find the tenant at home. Because if the tenant was at home and the process server didn't enter the building, which that happens fairly frequently, or entered the building and didn't knock on the door, which is important because they have to try at least to get your attention. And if they didn't do that and try and serve them to you by hand, then they're not doing it properly, right? This is complicated a little bit, but it's something that the benefit that you can deliver to the tenant here is just to say, make a note, right? How did you find these papers? When did you find these papers? So that if they decide they want to contest service at a later time, they have like a contemporaneous or near contemporaneous, meaning close to the event, record of what happened. Okay, I think that's service is complicated. The one other note I wanted to make about service: if the process server finds somebody at home who lives there but isn't the tenant, they can serve that person, right? And that's acceptable. They have to follow up with the mailing, but that's acceptable. You may want to check the affidavit of service for that kind of allegation, saying, "Oh, I served this person or a person matching this description." Because often, not if they're a minor. Thank you for asking. Not if they're a minor child. But yeah, if oftentimes you'll see in an affidavit of service when the process server is just making things up, you'll see a description of someone who it doesn't match anybody in the household, and that's just a very good indicator that that service was not performed correctly, right? And that's
What about if it's a two-family house and you're renting somebody a room and you, the owner, happens to be home? Can the process server give you the notice?
So it depends on whether if they're renting a room in the same apartment, right? Such that you guys share common areas of the apartment, then I would think that would be okay. Because it's like a roommate. You can serve a roommate. It would be different if it were a neighbor or somebody living in a detached part of what had maybe once been a whole apartment.
Like
Um,
a daughter kind of set up in a house, but it's not that.
yeah, yeah,
With a separate
yeah,
entrance, I see, but right, this is different.
yeah.
So once the process server gives you the notice, you put it on the roommate tenant's door, bedroom door.
Well, You could put it on their bedroom door. You just have to I mean, if this is something like, yeah, I mean, if this is it, I haven't read cases on this specifically, but what my feeling is like, yeah, you would just give it to the tenant. Then, when you see them, you could slide it under their door, or you could say, oh, hey, this came for you, whatever, right? The thing is, I don't think that you can reject service on behalf of somebody else who's living in the property, right? In the apartment. I don't think that would be proper.
Okay.
Yeah. Just jumping in here. Every once in a while, a tenant will come to housing court answers and they'll be very fixated on the fact that maybe service wasn't done properly. Um, but sometimes, I mean, so if a person isn't served properly, can that tenant just ignore the court papers and not do anything?
No, that is a very bad idea, right? So what they should do if they get the papers, right? Because if they don't show up to court and they haven't gone in and answered, even to say like I didn't get these papers correctly, right? Like if they know about the proceeding, they should certainly go and answer because otherwise the landlord may ask for a default judgment against them, and then they'll get served with the marshal's notice of eviction. Then they'll go to court, and they may be able to say, they should be able to say, okay, yeah, I didn't get served correctly, but then the court is going to have to decide whether that's true or not. And it also skips the line to the very end of the proceeding, right? Now you've got a judgment against you that you've got to find a way to get vacated, and it puts you in a lot of immediate danger. So yeah, you're always going to want to counsel tenants to go in and answer the 14-day notice. They've got 10 days to do it. It's 10 calendar days. And the 10th day, if the 10th day falls on a weekend, then it's the following business day. But they should always go and fill out an answer by form. Okay, so yeah, this just goes back to I think we mostly checked or we mostly talked about this with the last slide, but I'll just read this off. So process servers often engage in bad faith tactics that aren't calculated to notify the tenant of the court case, right? Process servers often are given like, you know, 50 or 60 different service targets a day, right? And what they have to do is keep a GPS log of their whereabouts, right? And like make a little like click their GPS log when they get to a house, right? But if they're really just trying to like, get their numbers in and they don't have time to go in, knock on the door, gain entry to the building, go up the stairs, knock on that door, and serve them. Sometimes what they'll do is they'll just click their GPS thing, right, and take off, right? So, like, you do want to be careful about how they're saying they did this, right? The tenant is entitled to have somebody knock on their door, right? Gain entry, knock on their door, and see if they can find them at home. The front door, the entrance door to the building, that is not good enough, right? It has to be the actual apartment door. The landlord has access to the building, if not the apartment, right? So the landlord should be able to let them in. That's the law, right? And so the most important thing is that the tenant, just very quickly, yeah, the tenant in their answer by form check the box that says I was not served the papers as required by law, right? And then they'll want to flesh that out later, hopefully when they get an attorney. Okay, so when the case begins, so once the 14-day notice is expired, the landlord can file their eviction papers, and the tenant should be served with the notice of petition and petition with an index number identifying the case. And it's very important to get that index number so that if you want to consult with an attorney on their behalf or they want to consult with an attorney, they can give the index number, the identifying number for the court case, because we have access to NYSIF. You guys also can have access to NYSIF, but you have more limited access. NYSIF is the New York State Civil Filing Service, right?
Electronic
Filing.
filing.
Yeah. I'm not going to remember the exact acronym details right now, But that way, an attorney or an advocate who's comfortable using NICEF, and you really don't have to be, can look up the court case, see what the details are, see how far along the court case is. Hopefully, it's just at the answering stage, and then they can advise them. But that index number is very valuable because otherwise it can be difficult to find the proceeding online and the papers in the proceeding online. One of the things that's valuable about NICEF is it should have an affidavit of service filed with the court there and available, so you can compare what the way the landlord is alleging that they've served the 14-day notice to pay and the notice petition with the the tenant's actual lived experiences, right? Their personal knowledge. So the petition that the tenant will get, they'll get a notice of petition and a petition. They're served together. And the petition must state whether the parties have a written lease agreement, whether describe the tenancy, right? And that means whether the tenancy is rent stabilized, is protected by good cause eviction, or whether the tenancy is unregulated, right? You should always get a notice now about good cause eviction, but the good cause eviction notices are sometimes kind of confusing because there's a little box in there that says this tenancy is not protected by good cause eviction because it's covered by regulatory, like either regular, like city, state, or federal regulatory, law, right? That means that the apartment could be rent stabilized. So it's a little bit confusing that to tenants sometimes when they read something that says, oh no, like my tenancy isn't subject to good cause eviction, but in fact they may have a stronger protection in rent stabilization, right? So please keep that in mind. The petition should state whether or not the tenancy is rent stabilized. If the tenant has a Section 8 subsidy, the petition should say that, and it should also say what agency administers the subsidy. It might be NYCHA, it might be HUD, it might be, HPD administers some Section 8. And that's to make sure that the landlord has properly notified Section 8 that it's bringing this case, right?
And just so people know, we're going to have workshops on lots of these topics like good cause eviction, rent stabilization, etc. So if you want more details about that, more workshops should be in your future. Um, shameless plugging. Yeah, please go ahead.
Okay. So how to answer the proceeding? As I said, it's important to answer the proceeding, even if they didn't serve you the papers correctly, right? Even if you don't feel like you owe any rent, right? And then even if the landlord says, "Oh, I know you don't owe your rent. I don't know what that my attorney's just going crazy. Like, don't bother to show up." You hear that a lot, right? Don't don't let your clients, the tenants that you're advocating for, fall for that. It is always best to go down to the courthouse and answer. If your answer is I have paid all of this rent, then that's your answer, right? But like you're gonna want to make sure that you don't allow an unscrupulous landlord to again get a default judgment against the tenant and put them in a compromised position when they're entering this proceeding. Because yeah, it just puts it gets rid of some of the off ramps that they might have had in between, and we'll discuss that later. So at the courthouse, generally at the clerk's office in Kings County, where I practice most regularly, it's on the second floor of the housing court. You go and stand in line for a while, and then you answer by form, right? So you just check boxes. It's not a hard process at all, right? The clerk there will basically take your statement, and then they'll assign a courtroom and a date and time for the tenant to show up for their first court date. Next slide, please. So this is what the answer by form looks like, right? Super easy. right? You just you know, again, check these boxes, right? Like here's where at the top where you have the service issues that we were talking about before. You would want to check the maybe number 2 is the most often, you know, the box most often checked. I received the notice of petition, but service was not correct, right? Like maybe you only received it by mail, right? Maybe like you found it in the hallway downstairs, right? And or outside of the front door, right? Whatever. Um, uh that's a box that you can check. You should, if the tenant has like questions about service that seem reasonable, they should check that box, right? Parties, right? Rent is an important one. The petitioner owes me money because of rent overcharge, or I had to like pay for repairs or services, like maybe my refrigerator broke and I talked to the landlord about it over and over again, and I couldn't live without a refrigerator, right? And so I had to spend $500 on a refrigerator. I don't owe that, right? Um, the petitioner didn't ask me for the rent properly, and like by sending me a 14-day notice, um, or the monthly rent that they asked for is not the amount that I've agreed to in a written lease agreement, right? Um, the apartment house zip code, especially sometimes can be very important, right? Like maybe they have the address right, but the apartment number wrong. That's a basis for dismissal. Maybe they have the address and the apartment number right, but the zip code is wrong. Like that's a basis for dismissal. You don't see it so often, but those mistakes do happen, right? Um, and then at the bottom, you should always check general denial, right? That just says I'm not admitting to the case that the landlord is bringing against me. I want the landlord to prove it in court, right? Um, but it also has other good defenses, right? Latches, meaning that the landlord has waited for so long, like maybe a period of a year or more, depending on what borough you're in, but a year or more. And the purpose of this was to wait until the amount of rent, they believe the amount of rent that I owed was insurmountable, so I couldn't pay it, right? And because they've waited for this long, I want the court to, you know, to if they order issue a judgment that's not attached to my right to live in the apartment, right? You might uh you might you might you know, maybe you can get a judgment against me in civil court, but that would be like a creditor judgment, right? It wouldn't result in me forfeiting my right to live in this apartment. That's the weird thing about how rent debt is different from other kinds of debt, right? Like if you don't pay your credit card bill, you might owe money to your credit card company, but they don't come and take your apartment, right? Rent is different, right? There are different rules for it, whether that's good or bad. You know, it's a big topic, but I think it's bad. New York City only, the petitioner has harassed me. That's a whole topic of conversation, what the definition of harassment is. I've taught many classes to lawyers, and also done lots of presentations for non-lawyers about this. And you know, there's always more to ask and talk about. But generally, what harassment means is that the landlord has acted or failed to act in a way that is intent to force the tenant or lawful occupant out of their apartment, or has caused them to, or is intended to cause them to give up a right related to housing, right? And that could be their right to repairs, their right to receive like um inspections by government agencies, right? Say the landlord is falsely certifying that violations have been corrected, something like that. Or a handful of other things. Again, just too big of a topic to go into right now. Uh, I serve in the military or depend on somebody in the military. That's a very important one if that's true, because there's a whole procedural process for that, and the landlord should have made an inquiry into whether or not the tenant is in the military before bringing the non-pay. Again, the petition seeks HUD or housing authority section 8 part of the rent. Counterclaims based on the above defenses. I think they're thinking of overcharge there, right? Or warranty of habitability. The landlord has failed to make repairs, right? You can counterclaim with that as well. And then if you see down at the bottom, this is where it gives you the court date, right? And the part. Here it's been assigned a court date of March 15th, 2019 at 9:30 in Part J, which is room 502 of the Brooklyn Housing Court. And so now
oh, whenever people see part and then a letter, or even a number, part just means courtroom for non-lawyers. It's a weird thing for non-lawyers.
Exactly.
And Sam, there's a question in the chat, what can be done when the landlord blocks a payment portal or, refuses to deposit a payment, by check or whatever. I imagine the person would mark the line on this answer form, but do you want to address that, or do you want to address that later?
I can address that quickly now, and then if you have more questions later, I can talk about it later. But yes, they should definitely say I tried to pay the landlord the rent, but they wouldn't accept it, right? That wouldn't necessarily mean that you don't still owe the rent to the landlord, but what it does is it signals to the judge this isn't about rent anymore. This is just about money. If you owe that money to the landlord after they've refused to accept it, right, then you can go to civil court and you can ask for a judgment there. But I'm not going to threaten to put the tenant out of possession of this apartment to kick them out because they owe rent that they tried to give you and you refused, right? There's a law. There's a part of the Real Property and Proceedings Law, RPAPL 235E, which deals with receipts for rent, right? Specifically, non-receipt of rent. If a landlord hasn't received rent within 5 days, they're supposed to send you a letter by certified mail, right? Saying we haven't received this. And if you've tried to pay and they haven't sent you that, you should definitely make a note and tell the court.
Right. Maybe next slide.
Oh, just a quick question. Sam, suppose people the lease renewal. If they refuse to sign the lease renewal, then the lease expires. You're supposed to do a lease renewal and they're not signing it, then that's also, you could go to court for that.
You can. So we're not going to discuss holdover claims today, right?
Okay, that's in a holdover case, right?
That's
okay.
in a holdover. Yeah. So that's in the context of a holdover. And in that holdover case, the landlord would have to prove that they gave the tenant a lawful lease, a lease that complied with all of the laws. So if it's rent stabilized, it has to be a lawful rent stabilized lease, right? And that's a very important point for that type of holdover. The effect that it has on a non-pay to not have a lease is that the landlord can't really bring the proceeding, right? This is something the court has clarified over the last 2 years, especially. An eviction case in housing court can only be brought for breach of terms of a rent agreement. And if the landlord and tenant don't have a current rent agreement, there's no term to breach, right? And so the tenant should always say, if they don't have a current lease, I don't have a current lease, because that can be a full stop, throw this out.
Right, but if you have proof of the lease renewal and you signed it and their current lease expired and they didn't sign the lease renewal, then what?
Same thing holds for a non-payment. The landlord's remedy is to bring a holdover against them to force them to sign that lease. They can't address that in the non-payment case.
Right. But you have to have a lease anyway, because how are you going to function for years and years without one? That just doesn't make sense to rent
Yeah.
an apartment. It's
So
either
if
they move, it's gonna be done through the court system,
So,
period.
yes, if they're to be evicted, it has to be by court order. Frankly, I counsel a lot of tenants who are rent stabilized and don't need to show a current lease for a benefit or subsidy. I tell them not to ask for them because if you're rent stabilized, you're entitled to renew a lease every time your lease is up, and it doesn't change your rights if you don't get that lease. The only thing that a renewal lease does for rent stabilized tenants is it increases your rent. So why ask for it? You're fine without it. I know that flies in the face of a lot of like sort of common sense thinking. And a lot of tenants are going to feel very insecure without a lease, and that's totally understandable, and you should speak to it. But from a purely legal standpoint, if they're rent stabilized, that lease is not doing them a renewal lease isn't going to do them any favors unless they need it to show like a benefit like SCREE or DREE or
Right, but it's not about applying for benefits. It's just about between you and the landlord and what is the current rent. And you can't go 5 years without it. It's a 2-year lease option or a 1-year lease option. That's it. But
but this is the thing. If you're rent stabilized, you're and not if you refuse to serve to sign
but
a
the rent
right?
guidelines board makes the rates every year and you choose a 1 or
That's
2-year
correct.
lease option.
Right,
So,
but just quickly, so if you're rent stabilized and your lease expires and your landlord doesn't give you another lease for five
oh,
years, it doesn't matter.
that's crazy. But
Your rent just doesn't go up, right? Your
yeah,
landlord
but
has to
anyway,
offer you that lease, and they have to offer it to you in a very particular way.
so yeah,
In
it's supposed to be 90 days or 60 days. But anyway,
exactly,
let me
it's
let
60
you go
days to
on. Right,
consider, 90 days before it takes effect.
right. Okay, go ahead.
Okay. All right.
Uh,
So what? Yeah,
do you want
please.
the next slide or do you want this one?
Um, I think we talked about all this. Yeah.
Okay, cool.
Okay. Resources. This is important, right? If the tenant is feeling anxious or having trouble and wants help to discuss the process with an attorney or advocate, obviously other than yourself, right? Before uh the court the next court date. And I should explain this if I haven't yet, right? I don't think I have. Right. I think I'm going to explain it on the next slide, but there's a large gap between the time that the tenant goes to answer by form, right? Goes to the clerk's office, and the time that the first appearance is scheduled. And we'll talk about the first appearance in a minute. But in Brooklyn right now, that gap is about 5 months. Oftentimes in the past, you've seen like 2, 3 months. But right now, because housing court is very backed up, it's likely that you'll have a long period of time between the time that the tenant answers and the time that the tenant has to appear in court, right? So that might be a good time for them to go and do something like call 311 and ask to be directed to a tenant helpline, where they'll be assigned to speak with an attorney like myself, who can help talk them through all of this. Send the tenant to the local official elected's office and asked to speak with constituent services, right? They can help the tenant often apply for assistance. Contact local community-based organizations that assists with like tenant advocacy. And a good way to find that is by, I don't know if Housing Court Answers has that on their website. Great, yeah. Met Council also have a really good page for that.
Yeah, a lot of the time with housing court answers, we ask that the people call us and then we try to figure out based on where they are, what would be the right org for them to be
Right,
reaching out to.
right. Because a lot of the organizations are very regional. Yeah. Okay. And then also, yeah, call the Housing Court Answers hotline. Also a really good place to start if you want to refer the tenant to speak with someone who may be able to offer them resources or talk them through this process.
Yeah, and also we do really, really basic workshops where we explain like, this year, this presentation is for advocates, right? But we also have like way more elementary versions of this for tenants themselves that we do on Zoom. So something to think about.
Okay, so one of the things that the tenant can do in between the time that they answer and the time that their first appearance in housing court is they can start thinking about applying for assistance in their rental arrears. Hopefully you guys are all familiar. I'm sure you guys are all familiar with the city's one-shot deal program, which helps tenants to pay arrears. Usually not like usually it's like what they say the cap is about 10,000, right? But you know, it gets a little bit harder when it's 20,000. It gets a little bit harder than that when it's 30,000. Above that, it starts to get like very difficult, right? But they should always go and apply, right? They can apply at their local home base office or the HRA office at housing court. Most housing courts have them, I think, now. Or they can apply online at access.nyc.gov, and they should be prepared to bring proof of the following, right? So birth certificate or social security number and a photo ID for each adult in the household, right? And that's just a picture of a photo ID, right? Proof of income for all members of your household, right? So that should be like, you know, either a social security award letter or check pay stubs going back like, you know, three three payment periods, bills or letters from the landlord for monthly rent, right? So you like that 14-day rent demand, right? You could bring that in. Copies of court orders, right? So if you're further along in the process, but also you could bring in the notice of petition and petition just to show them, and a lease, right? Showing the last lease you have, right? Showing what the proper amount is.
Yeah. Sam, this is going back a little bit, but I think it's quick. When a tenant doesn't answer the petition within the 10-day window, what should they do?
They should go ASAP, immediately to the clerk's office and try and answer there, right? The clerk may inform them that they've taken too long. Usually 10 days, like it's, you know, you don't want to advise anybody to wait longer than 10 days, right? Because then they're in a danger zone. But usually it takes about 3 weeks or a month before a landlord will apply for a default judgment against the tenant, right? So all hope is not lost if it's been a couple of weeks, you know, maybe even 3 weeks. The tenant should go to the clerk's office and try and just file that answer a little bit late, and there may be no penalty for it. They can also call 311 again and ask to be to speak with a housing attorney. That housing attorney can look online and see whether the landlord has applied for a default judgment. Because the landlord has applied for a default judgment, what they should be doing at the clerk's office instead is filing an order to show cause to stay the eviction or to vacate the default.
Thank you. Great.
Okay. First appearance. So some of this I already spoke about. I think because I just find this so crazy. Like I've been doing this for 12 years, and this is just like the longest time you've seen in between the time that someone files an answer and the time that the first court appearance is scheduled. But yeah, like again, there's a long gap between that answer period and the first appearance. The first appearance date, again, like this is one of those good opportunities to tell your client that they're not going to be evicted immediately. The first appearance date is like a freebie, right? The tenant should go. They should expect to speak with an attorney to bring all of the papers that they have with them, including their lease, their last lease, any proof of payment, that sort of thing. But they'll be given an opportunity to speak with an attorney from legal services who will review their case to see whether they can take it on. And even if they can't take it on, they can advise them of defenses that they might have, and you know, any claims they may have against the landlord, right? And how to assert those properly. They'll also be given an opportunity that day, or should be given an opportunity that day, to go to the HRA office and apply for a one-shot deal if they need help with paying back arrears. And then the proceeding will just be rescheduled, right? They shouldn't agree to anything with a landlord's attorney outside of just when to reschedule the matter, right? They shouldn't really be speaking to the landlord's attorney. Landlord's attorney, if they ask them, to settle the case at that point, unless the tenant has all of the money like on them right then, right? Like not future stuff, that tenant should not be speaking to the landlord about anything regarding settlement. They should just be like saying, I want to speak to an attorney, and that's it, right? And the judge will understand that. That's not controversial, and they shouldn't be made to feel bad about that. And then the case will be rescheduled usually between 3 and 6 weeks out. 3 weeks is about right, and the tenant will be asked to come back at that time. They should have an answer by the time they come back from the legal services organization they met with, about whether or not that legal services is capable of representing them at the time. We all have very high dockets, meaning we all have a lot of cases, so it's hard for us to take on new stuff sometimes. But they should have an answer by then. If they've they feel like they haven't, they really want an attorney, and it doesn't seem like the legal services that they met with is going to be able to represent them in the matter, they should go to their city council person and say, hey, I'm really having trouble. Can you help refer me to a legal services and see if that will help? It's no guarantee, but your council member has an interest in keeping their constituents in their homes so that they can vote for them when it's their time, right?
That's so true. Just at housing court answer, we noticed that sometimes tenants are not really clear on who it is that they're talking to at any given moment. So we'd like to encourage people, and maybe the advocates here could encourage tenants to always ask who they're talking to, right? Sometimes they get confused. They think the landlord's lawyer is their lawyer, or
Yeah.
sometimes they went to the legal aid type room and they don't know what organization they talk to. So
Yeah,
just
yeah, yeah. That's a really good point. Make sure that they take notes of who they spoke to and what organization they were at. Because they may want to, when they come back, say, "Oh, I spoke to the judge. I spoke to this person at this organization. I haven't heard back from them yet." Right, and the judge may say, "Oh, I know that person." Right, and then they might be able to help them get in touch and get a more definitive answer. Okay, so part one, trying to resolve or settle the case, right? So again, this goes back to what I was saying before about how long the process takes, right? Again, likely at this point, it's already been 5-6 months since the tenant answered the proceeding, right? And then again, they've had at least one adjournment to speak with an attorney, and possibly another. You can ask for a second adjournment to speak with an attorney if you need one. And that's just to say, the tenant isn't going to be evicted isn't going to be evicted within the first several months, right? Like they're not even going to be in a position where they might be in danger of eviction, right? First, they'll be sent to what's called a resolution part, where that judge is not going to try their case. That judge is just going to see, what can I do to help these parties settle this matter, right? And that might be like, oh, the landlord brought this non-payment proceeding, but I don't have a lease and I haven't had a lease for years. And so the judge might say, okay, well, that sounds like the landlord doesn't have the right to bring this, right? And they're not in a good position to bring this. So I'm going to chuck this case out, right? Some judges will say, I want to have a motion on that. And so the judges will hear motions in the resolution part. All of the motions that are made in the case, generally speaking, should be made in the resolution part and this pre-trial part in front of the pre-trial judge. Before that judge decides, okay, this matter is not settling and I don't see a reason why it shouldn't go to trial. And then only then will they assign it out to a trial judge, right? So this process from the time that it's sent to the pretrial judge to the time that it's sent to a trial judge, that should be another 2-3 months, right? 2 months on the short end, right? Like 3, 4, 5 on the longer end, depending if they have an attorney. If they have an attorney and the attorney wants motions heard, then that can really delay the case, right? But again, it's just important to show them, to let them know you and your family are not in danger of immediate eviction, right? As I said before, the tenant is able to adjourn, reschedule the case twice to speak with an attorney. If the landlord is offering something that the tenant wants in exchange for settling the case, the tenant can do that. I strongly suggest that no tenant agrees, especially in a non-payment case, to vacate the apartment, to leave the apartment in exchange for a waiver of rent, unless they have a new place to go. Not they suspect they might, not they think they will, not like, oh, this place is a dump and I want to leave, right? Like, but they have a place to go. That is the only time when they should be settling for possession. And this is not like, oh, I'll give you 6 months to leave. No, because the housing crisis in New York City is not going to be abated in 6 months, right? And like, really important that even if the landlord is making an offer that sounds very good, right, the tenant not agree to do something that might put them out on the street, right? I think I had some questions.
So one of them, I wanted to save it for the Q&A
Oh,
part
okay,
at the
great.
end, but
All right,
yeah,
sure.
thank you. All right.
Okay. Going to trial. So when the pretrial judge determines that the case is ready for trial, they'll issue an order sending out the case to be heard by a trial judge. Even then, when the trial judge receives the order, they schedule a pre-trial conference, giving everybody a last opportunity to settle the case, right? The trials they're resource heavy for the city, right? They cost a lot of money because everything has to be recorded, and trial judges are just they're not able to hear lots of other cases while they're doing trial, right? So it's very heavy, like hard on the resources for the housing court judges, which is why you only have 3 or 4 trial judges assigned to any borough, right? Any county. Most of the judges are really there in the resolution parts, and they hear lots and lots of cases per day, right? So the trial judge is really going to say there must be a way for you guys to settle, right? And at this point, hopefully the tenant has the money, right? Has gotten their one-shot deal approved, or is on the way to getting their one-shot deal approved, and can show that, right? And like, this is a good time to discuss. Hopefully, yeah, again, hopefully the tenant has an attorney by this point. It's very, like, I really cannot recommend that a tenant go to trial without benefit of an attorney. Unfortunately, trials are they're just hard to crack. Like, I remember my first couple of trials, they were difficult. Now I'm pretty comfortable with them, but like, yeah.
But that honesty is so valuable.
Yeah. It's not, yeah, it's not it's gonna be difficult. But
Yeah.
not possible.
Um, Nobody asked this, but
Sure.
advocates might not be aware, juries are kind of unusual
Yeah.
in housing court trials. Like a housing court trial wouldn't look very similar to the trials we see on TV, right? Do you
Yeah.
have
No, no, no,
the whole
no.
idea of jury trials?
Yeah, so that's a really interesting point. Okay, so almost all leases, meaning the first lease that the tenant signs, right? What's called a vacancy lease, the lease that binds the tenancy, really, when they move in. Almost all of them have a clause waiving the right to a jury trial, right? And that means that when the tenant goes to court, right? Like, if they say, hey, I want a trial by jury, which they have a right to outside of a contractual agreement not to, the landlord shows up with the original lease and it says that the tenant has waived their right, then there's no jury trial. generally speaking, the court doesn't give you a lot of opportunities to do a jury trial because I mean, like as I was saying, like a trial is resource like saps a lot of resources. If you're going to bring a jury into it, that saps even more resources. So they're not going to like nudge you into doing trial by jury. And this also can help tenants when they bring cases against their landlords for repairs. Occasionally, you'll get the landlord attorney saying, I want to do this by jury, right, to delay the matter. And if you can whip out that lease that says, nope, you waived your right, because this is a reciprocal right, then, it can benefit the tenant as well. The nice thing about it is that housing court judges, I mean, they're a very mixed bag, but for the most part, they're there with a very good understanding of the law, and they really just want you guys to speak to the law. It's not about making like an emotional pitch to a jury, right? And looking for sympathy. Usually, the judge doesn't, they've been doing this for long enough where they don't necessarily need to a sympathy buy.
Interesting.
Yeah. What happens after trial? Okay, so if the judge decides that the tenant owes any portion of the rent that the landlord demanded, the judge will issue an order directing the tenant to pay a money judgment and awarding the landlord a judgment of possession, right? So this is important, right? Say the tenant goes to trial and they say, I have had these terrible conditions in my apartment for years, right? And the landlord has known about it and they prove that the landlord knew about it. Maybe they show that these repairs have been cited as violations by the city, and the landlord knew that way, right? And the landlord refused to fix all kinds of things in their apartment, and the judge says, okay, tenant, I'm gonna agree with you. I'm gonna say you don't owe 90% of the rent, and that would be very unusual. Usually it's a lot less. I'm going to give you a 90% abatement. Even if the tenant owes that 10%, the judge is going to issue an order saying you have to pay this. And if you don't pay it by within 10 days, right, then the landlord has the right to send a marshal's notice, right? And then, you'll get evicted if you don't pay it, right? This is part of the reason why trials are so difficult, right? Is because, like it's possible that the tenant just doesn't have any money, right? So even if they get a really good, what's called an abatement, which is a discount on what they owe, right? Um, they may still need a one-shot deal, right? And that doesn't mean that it's the end of the story. But again, things get kind of scary when there's a judgment against you, right? Um, uh, Even if the tenant pays, this is super, super important. Never rely on the landlord just being a reasonable person and saying, "Oh, sure, I accepted the rent, and so I'm not going to enforce this eviction like notice against you," right? Like, no, go back to the housing court, go back to the clerk, and show them the proof that bring an order to show cause and show the proof that you paid off the judgment and ask for the case to be dismissed and the warrant to be vacated, right? Just ask to speak to the judge, right? Say like, I just want to make sure I've crossed all my I's. Wait, no, crossed all my T's, not all my I's. Crossed all my
Dotted
T's.
the I's.
I want to make sure that I'm no longer in danger. I want the court to just write out something that says this tenant is no longer in danger of eviction. This case is over, right?
Yeah. And sometimes tenants get confused, like they assume, well, shouldn't the court be aware that HRA paid off my arrears? And
Yeah,
they
yeah.
don't realize these institutions are not talking to each other.
They're not. They're not. And that landlord might be sitting on like bags and bags of money, but it's not necessarily like they're not necessarily going to go out of their way to tell the court, oh, this judgment has been satisfied, right? They, who knows why? Landlords behave badly all the time, and you just want to watch out for that.
Yeah. Um,
Okay. So what happens if the tenant receives a notice of eviction? And this this happens when the court enters a judgment, right? And the court can enter a judgment after trial. The court can enter a judgment after the tenant signed a stipulation agreeing to pay by a certain time and they weren't able to, right? Or if the tenant like doesn't show up at some point and the landlord gets a default, the court at that point they'll enter a judgment, right? And I don't think the court will feel fine doing it, right? For the most part, because like, the court needs to be given a reason not to evict the tenant at that point. And that's where an order show cause comes in. The order show cause is showing, it's there to show the judge, get the case back in front of the judge and give the judge a reason not to evict the tenant, right? And the court is going to want to see some evidence, right, that if they made an agreement to pay, right, that or there's been a trial and they owe something, right, a judgment has come down, they've made some effort, right? And this could be as simple as showing a completed one-shot deal application, right? And then also maybe ongoing rent, right? So like maybe you couldn't pay for the arrears, right? But you got money through January, and here's also a receipt for the February rent that I paid, right? Or here are other efforts that I've made to pay off this debt, right? Please just give me a little bit more time so that I can come up with this money so that HRA can come through with this one-shot deal. I've done everything I can, right? Maybe this is not a regulated tenancy, right? It's not subject to rent stabilization or good cause eviction. It's just a market rate tenancy, right? And so the tenant can't has decided instead I'm just going to move, right? And maybe that's reasonable, right? But as I said before, the city is undergoing, as you guys all know, and are working to against the city, it has a really serious housing crisis, right? So tenants who sometimes agree to leave when that leave by date comes up, they still need more time. They should go back to the court and again show that they paid like the interim rent, right? Or made attempts to pay it, or I have it in court that day to pay. And that they've been looking for another place to live. And that's as easy as like printing out like ads from Street Easy or Craigslist and saying like, look, I went to this open house, I went to this open house, I went to this open house, right? I can afford these apartments, but nobody's accepted me yet. And I continue to make these efforts, right? Oh yeah, it's also important to inform the tenants because this happens a lot, right? Maybe the tenant will say, okay, you pay me, or I'll pay you by April 1st, right? And then you'll make repairs by April 1st, right? And the landlord will say, great, easy peasy, right? And then the landlord will not make any repairs at all, right? And the tenant will say, well, then I'm not going to pay, right? But that does not relieve them of a judgment of possession against them, right? And it's very important to make sure that tenants know it's not fair, but it's the law, right? Like it doesn't matter, unfortunately, that the landlord has not fixed things. If you've agreed to pay them by a certain date, that has nothing to do, unfortunately, with the repairs because you've agreed to how much you owed and agreed to a payment date. And again, that really it's not great, but that's you want to prevent somebody from putting themselves in a bad position where they could get evicted.
Yeah. And just wanted to also mention that if a tenant is on their own and doing this order to show cause process, they can go to that. If they're there in court Monday through Thursday, they could get help from the Housing Court Answers table. We help people to try to write the things that need to go on the form because sometimes tenants are just all over the place. Getting help when you can, especially when we're right there nearby the clerk windows, it can be helpful.
Okay. So, but that again, if the tenant is having issues, I think we went past that one. So slide 18. Right. So there are other ways, like if the tenant, like, and this happens a lot, right? Tenants often stop paying rent because like they're not receiving repairs and essential services from their landlords, and they want it to stop, right? And they have the good sense to know that they shouldn't be paying 100% of their contract rent when they're not getting 100% of the value of their leases, right? And they're right on the law about that. So long as they have let the landlord know about all the conditions and have given them an opportunity to fix, and the landlord has refused to do it, they should not be paying 100% of the rent. But oftentimes when like landlords sort of know that, right? And they'll let the tenant go on the rent, knowing the tenant is withholding rent for a year or more, right? And wait until the tenant owes so much money that when they bring them to court for eviction, the tenant might say this is about repairs, but really at that point, it's about paying off the money so they don't get evicted, right? And they might make agreements, as I said, with the landlord at that point, to for the landlord to make repairs, and the landlord might default on those agreements, right? But really, the tenant has got to pay that money to not get evicted, right? More than anything else. That's the number one. That's the number one thing, right? So what do, right? They should fight back and take the fight to the landlord, right? They can organize a tenants association. They can work with community-based organizations to do that, right? They can file a case on their own, right? And all of the housing parts, all of the housing courts were originally created so that the city and tenants could bring cases against the landlord, not so that landlords could bring cases against the tenants. That was like an afterthought, right? Like they can go and file what's called an HP, which is a housing part proceeding, asking for the court to order the landlord to make repairs. And if the landlord doesn't, to fine the landlord. And ultimately, if the landlord still doesn't, to throw that landlord in jail, right? So it's important to know that you can continue to fight for repairs even if you haven't gotten them in your non-payment case. Okay, guys. Here's my contact information in case you guys have any questions about that. But again, like you can call 311 and ask to speak with a housing attorney if you have questions about how to file a case against your landlord for those things. It's pretty easy. You go to the clerk, same way as you would to answer the non-payment eviction case. You'd go to the clerk and you'd say, hey, I want to bring a case against my landlord for repairs, right? And always call 311 to see if you can get the city inspectors to agree with you and write violations. That's gonna get you far along on your case. If you show up and you say, hey, there are 30, 40 violations on my apartment, the court and the landlord and landlord's attorney should take that very seriously.
Yeah. Thank you, Sam.
Sure.
So I know that you have a meeting that you have to run to. There was a question in the chat I wanted to circle back to. Okay, so it looked like Ken in the chat had a question regarding the different function of I think the general helper information office on the first floor of housing, or oh, it's the help center. The help center, that's Manhattan first floor,
Yeah.
and the clerk's office, the help center with the court attorneys, etc. Would you maybe be able to speak to that?
Not so much because I don't practice in Manhattan very often. So I'm not super sure about that. I can tell you that that if it that I mean the help center, for instance, in Brooklyn Housing Court is on the fourth floor. That's a good place to go to ask about how to file like orders to show cause if they're not helping you on the second floor. Second floor would generally, if you're not if you're basically gone to the wrong place, they may refer you to the help center on the fourth floor. They can help you to make copies of documents. And generally they can give you some pretty good advice, right? um, uh, from what I know. Um, Ultimately, the best place to go for advice is to the legal services organizations, right? Because they are going to be able to just tell you more about advocating for yourself specifically, where the help center has to be a little neutral.
Oh, right. Yeah, because a court attorney, people, I mean, tenants do run into or encounter a lot of different attorneys in a housing court, but sometimes they get confused about who is on whose side, etc. I mean,
Yeah,
even getting the landlord, sometimes think the landlord's attorney is yours, like no. And then court attorneys, they're employees of the court, right? They're not there
right. They're employees
necessarily.
of the court. They can tell you some things, right? And you may get a housing court like a court attorney, right? Like they're what they are is they're the judge's attorney, right? Who deals with the legal matters before they go to the judge often, right? And so you make conference with a court attorney rather than conferencing with the judge themselves if the judge is busy. And the court attorney may be on your side, but they may not be, right? It really depends on that attorney's perspective and background. They may tell you lots of helpful things, or they might not tell you anything at all, right? It's different for a legal services attorney because that legal services attorney is really there to help you, you
Yeah.
know?
So I don't see more questions in the chat, but maybe on this topic of lawyers, because clearly they're so valuable and it's such a struggle for tenants to talk to lawyers at various times. I don't know if you maybe wanted to just plug the legal clinics that can.
Oh yeah, sure, of course. Yeah. So as I said, I staff a legal clinic in Bushwick at Assemblymember Davila's office on the first and third Tuesday of every month. But my office staffs a number of clinics. We've got somewhere between 10 and 15 right now, often at elected officials' offices, but also with other community-based organizations. We staff one at the Queens YMCA. We staff one with Catholic Migration, and a bunch of other legal services. And that, it can be very helpful to go directly to a clinic to have an attorney look over your eviction papers, and advise you.
Um, oh shoot, other question. Um,
Uh,
y-
yes, I
so
have a question.
Mhm.
1 second. I wanted to know if Housing Court Answers has like a referral for landlords that deal in landlord housing court. When you're S Corp or LLC, let's say, and you're not, Jane Doe or, Janice Hamilton.
So if the landlord is incorporated in some way, honestly, we tell people to contact the New York State Bar Association because, in fact, if a landlord has incorporated, they're not actually allowed to, like, they have to be represented by a lawyer. Like, they
So in
can't
other
just do
words,
it themselves.
like one of my two family houses in my name, Janice Hamilton, and then the building I inherited from my parents is LLC'd. So it depends on which building I'd be working with. So the
Mhm.
one that's individually owned, the two family, with the room board or whatever, that I could do on my own without a lawyer, right? I would just use the legal aid to give me the papers and the court clerk in housing court to give me the documents to file. But the LLC one, the apartment building, I guess I'd have to go through bar association
Bar
to
Association.
get help. Right.
At least that is
Uh,
where we would send you. And we often send small landlords to the help center in housing court as
That's
well.
right. That's right. The
where's
help center
where's the
can
help
be.
center in housing court, by the way? It's inside housing court?
It
Mhm.
depends on the borough. It's
Like in
inside the
Brooklyn.
courthouse. It's inside the
So,
court, but the
In
actual
Brooklyn,
location, you would when you get to the housing court, ask a court officer, "Where's the help center?" and they should send you to the right place.
okay.
yeah,
And
in
there's legal
Brooklyn,
aid in there too? Legal aid is also in there? But legal aid
so
is more for tenants, right?
legal aid is on the 13th floor. The help center, which is open to everyone, is on the fourth floor. This is in Brooklyn, Kings County. The
Right.
help center is on the fourth floor. And if you just take the elevators up, the elevators open right in front of the help center.
Right. Thanks a lot.
You're welcome.
Let's see. Oh, sorry, another question. How can the landlord be preventing payment or blocking a payment portal during the 14-day rent demand period?
How can they, or why can they, or why would they, or how could they, or what?
Uh, well, I guess the how, oh, how can it be permitted as a matter of due process?
It's not. It's not. And you should raise that as a defense in your answer. Saying the landlord, I tried to give the landlord money and they wouldn't accept it. I tried to give them through the portal. I mean, I don't like payment portals for a number of reasons, and generally advise against them. But if you can get some screenshot saying like, from a payment portal where the landlord is obviously refusing to accept payment, even if it's partial payment, right? Which happens sometimes. They're like, oh, I only accept the full rent, right? You should definitely screenshot that and keep it so that you can, assert that defense.
So that looks like all the questions we have, and I just want to thank you, Sam, for doing this presentation for us. I hope
I hope
everybody
it,
was able to
yeah,
learn a lot.
yeah, I hope it was helpful.
Yeah, great. So everybody, thank you for being here, for tuning into our workshop series. More topics that really dig into these different issues, good cause, rent stabilization. We also, on Wednesdays, we have a series on assistance programs that like subsidies that help people stay in their apartments. So lots of stuff to check out on the Housing Court Answers website. And we will make sure to put this slideshow onto our website as well so that you can return to this great information later. And this recording will eventually end up on YouTube as well.
Thanks, everybody. I've gotta run. Thanks so much. Bye.
All right. Thanks, Sam. All right. So thank you to everybody and hope to see you at another workshop in the near future. Bye-bye.